I call this meeting to order. Welcome to meeting number 12 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to an order of Thursday, March 31st, the committee is meeting to study Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. Members are attending in person in the room and remotely using the Zoom application. This proceedings will be made available via the House of Commons website. And I'd like to welcome the first in-person meetings in this committee since we've started this parliamentary session. So I'd like to now welcome our witnesses. I think we have here in person two witnesses from Mothers Against Drunk Driving, Eric Dumchad and Steve Sullivan. And then we have from the Canadian Bar Association, Jody Burks and Tony Pasana are virtually appearing. And from the South Asian Bar Association of Toronto, Janani Shanmuganathan, who's the director. I think her camera is probably off, but she's there, I believe. So each one of you will have 5 minutes as a group, so you can split it amongst your team. And then afterwards there'll be rounds of questionings. I will give you and the questioners a 30-second kind of warning signal, and then I give an out of time, so I try to be as liberal as possible, but in that perspective. I'll now over to you, and we'll begin with the Canadian Bar Association.
Thank you, Chair. My name is Tony Paisana. I am the chair of the CBA's Criminal Justice Section. I am joined by my colleague, Jody Burks, the immediate past chair. The CBA represents approximately 36,000 lawyers, students, and jurists across Canada. The Criminal Justice Section in particular comprises a mix of both Crown Counsel and Defence Counsel. And it's from this unique, balanced perspective that we appear today and offer our commentary on Bill C-5. I will be addressing you on the provisions in this bill relating to CSOs, and Mr. Burks will deal with mandatory minimum sentences. Put simply, the CBA supports Bill C-5. As stated in our brief, this legislation will lead to a fairer and more just sentencing regime, one that recognizes that criminal offenses can be committed in various ways, and that one size does not fit all, particularly when it comes to offenders from traditionally marginalized communities. The lifting of prohibitions on CSOs is among one of the most important reforms in the criminal law over the last decade, in our view. We make several points about CSOs, but I'll highlight three here. First, CSOs are vital to the proper functioning of the criminal justice system and to ensuring that non-dangerous offenders are encouraged to rehabilitate rather than harden themselves within our prison system. I emphasize and reiterate, CSOs by statute can only be granted to non-dangerous offenders who commit an offense deserving of less than 2 years in custody. Second, making CSOs available does not mean that you will receive it. Indeed, I successfully argued a constitutional challenge to some of these very provisions in a drug trafficking case called Chen, but the trial judge nonetheless sentenced my client to nearly 4 years in custody. The sky did not fall, but as a result of that decision, numerous other marginalized accused have access to CSOs where appropriate in British Columbia. What we are talking about is affording sentencing judges more discretion, not less. Suggestions that serial rapists, human traffickers, or other serious offenders will now liberally be afforded CSOs are fanciful in my respectful view. These people will continue to go to jail as they always have. Third, the need for reform is urgent. As a result of a patchwork of constitutional challenges across the country, Canadians have inconsistent access to CSOs. If a drug-addicted mother of three commits a low-level trafficking offense to feed her addiction in the downtown east side of Vancouver, she is eligible for a CSO in BC. But if that same offender commits that same offense in Winnipeg or Edmonton, she is not. This lack of uniformity is troubling and inconsistent with our federal system. Each day that goes by, more non-dangerous offenders are sentenced to jail where they might otherwise be provided an opportunity to rehabilitate in the community, where access to programming, work, treatment, and counseling are more accessible and cost-effective to the state. So those are my comments on CSOs, and I'll now turn it over to Mr. Burks to touch upon mandatory minimum sentences.
Good afternoon, Mr. Chair. As Mr. Paisana mentioned, my name is Jody Burks. I join you today from the traditional territory of the Wendat, Anishinaabe Nation, the Haudenosaunee Confederacy, the Mississaugas of the Credit First Nation, and the Métis Nation. This land is covered by the Dish with One Spoon Treaty. If there is one message that the CBA has for this committee, it is this: Bill C-5 is not soft on crime. If and when Bill C-5 is proclaimed in force, it will not prohibit any judge from sending a single violent offender to jail. On the other hand, it will allow nonviolent offenders who deserve a second chance an alternative to incarceration. Mandatory minimum sentences have contributed to overcrowding in prisons, over-incarceration of marginalized communities, and increases in court delays as people litigate matters where they are guilty instead of resolving them. Additionally, mandatory minimum sentences have distorted the principles of sentencing. The fundamental principles of sentencing from the common law are now codified at Section 718.1 of the Criminal Code. And those principles are that a sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender. As a result of mandatory minimum sentences, instead of a sentence tailored to the seriousness of the offense and the record of the offender, we have a one-size-fits-all approach of jail for everyone, regardless of their circumstances. Allowing nonviolent offenders to serve sentences in the community allows offenders to work and support their families, receive treatment for their addictions which cause their offending, and give back to the community that they harmed through restorative justice measures. On the other hand, mandatory minimum sentences simply warehouse people until they can be released, often with diminished life skills, prospects for employment, and untreated for the problems which caused them to offend in the first place. My colleague, Mr. Paisana, has spoken about the changes to the conditional sentence regime in Bill C-5. But the short answer is, if an offense carries a mandatory minimum sentence, it is ineligible for a conditional sentence. As a result, without eliminating mandatory minimum sentences, the other aspects of this bill are useless. Bill C-5 represents the first step in recognizing the harmful effects of mandatory minimum sentences. The CBA supports the repeal of all mandatory minimum sentences except for murder. There is no harm prevented by mandatory minimum sentences, but a lot of harm caused by them. We look forward to answering the committee's questions.
Thank you. Thank you to the Bar Association. Now, if I can go to Mothers Against Drunk Driving, over to you for 5 minutes.
Thank you very much. Mr. Chair, members of the community, we appreciate the opportunity to speak with you about Bill C-5 today. My name is Eric Doomschat. I am the Legal Director for Mothers Against Drunk Driving Canada, and I'm pleased to be sharing my time today with my colleague Steve Sullivan, who is our Director of Victim Services. Much of the information we will discuss today here is expanded upon in the written brief that we've submitted with the committee, and this includes the appropriate reference information. MAD Canada is a national charitable organization with the mission to stop impaired driving and to support victims and survivors of this violent crime. We have volunteer-led groups in over 100 communities across the country, and indeed many of our volunteers are themselves victims and survivors of impaired driving. Our work is aimed at providing support to victims and survivors, raising awareness about the dangers of impaired driving, and saving lives and preventing injuries on Canada's roads. And we're here today to talk about the provisions of Bill C-5 dealing with conditional sentences and how they would impact victims and survivors of impaired driving. If the bill is enacted in its current form, it would allow for the return of conditional sentences for any first-time impaired driving offender who met the eligibility criteria, including those convicted of impaired driving causing death or the associated refusal offense. To put this in context, in 2018, as part of Bill C-46, the government repealed, revised, and reenacted the Criminal Code transportation offenses. As a result of this, conditional sentences were allowed for some new impaired driving offenses that were previously ineligible for them, so long as they were now tried by summary conviction. However, impaired driving causing death was excluded from eligibility for a conditional sentences, presumably because it was deemed sufficiently egregious to remain a purely indictable offense that carried a maximum sentence of life in prison. This decision is in line with the unanimous Supreme Court of Canada case, the Queen and Pruel, which held that conditional sentences should not be imposed where the need for denunciation and deterrence is so strong that incarceration is the only way to express society's condemnation of the conduct or to deter similar acts in the future. Med Canada believes that impaired driving causing death and its associated refusal offense meet this criteria. We recognize that it would be uncommon to see conditional sentence for someone convicted of impaired driving causing death. However, any chance of this happening is too high when a life has been taken by the actions of another. Med Canada does not believe that a conditional sentence for impaired driving causing death should be an option at all. To allow the possibility for an impaired driver who has caused the death to serve his or her sentence outside of a prison would undermine the seriousness of the crime and adversely affect many victims and their families. We need to remember that this is a completely preventable crime that continues to occur despite years, decades of advocacy and education efforts by Med Canada, other organizations, and indeed the governments of Canada. And yet Canadians still make the decision to get behind the wheel of a car while impaired by alcohol or drugs, and in doing so, take the lives of numerous Canadians each year. We understand that the changes contained in Bill C-5 are made in part to address the systemic racism inherent in Canada's criminal justice system, and we support this goal. However, the government has determined that some restrictions on conditional sentences are in line with this objective and constitutional, and that certain offenses should remain ineligible for conditional sentences under Bill C-5. With this in mind, Med Canada strongly recommends that impaired driving causing death, Section 320.14, subsection 3, and the associated refusal offense, Section 320.15, subsection 3 of the Criminal Code, be added to the list of offenses ineligible for a conditional sentence in any circumstance, as has been outlined in Clause 14 of Bill C-5. Thank you for my time and for the opportunity to present to you today. I'll now turn things over to Steve Sullivan, Med Canada's Director of Victim Services. Thank you.
Mr. Sullivan, I'll just remind you about have about a minute, so.
Okay.
Thank you.
Thank you, Mr. Chair. Med Canada is the only national anti-impaired driving organization in the country to provide services to victims and survivors of impaired driving. When conditional sentencing provisions were first enacted in 1996, families were outraged and felt re-victimized by the imposition of house arrest for someone who took the life of their loved one. Losing someone in an impaired driving crash is extremely difficult to deal with because it is something that is totally preventable, and because these deaths are not seen to be as serious as other criminal deaths like homicide. In 2007, the federal government enacted Bill C-9, which narrowed the categories and excluded impaired driving causing death. Med Canada and our volunteers, many of whom have lived experience, worked hard to eliminate conditional sentences for impaired driving causing death. People we support suffer from PTSD, depression, and anxiety. Many feel sentences for impaired driving causing death do not reflect the harm that has been caused, but for families, the intent and motivation of the offender is not significant. In recent years, courts have recognized the need for stricter sentences for impaired driving causing death, but we believe to allow for the possibility of conditional sentence in these cases which is entirely preventable act, suggests it's not a serious crime. Thank you, Mr. Chair.
Thank you. And hopefully, if you have more, we'll be able to extract it in the questions further. Next, I'd like to ask Janani Shanmuganathan from the South Asian Bar Association for 5 minutes.
Thank you to the Standing Committee for the invitation to present today. I am a Board of Director of the South Asian Bar Association, the largest diversity organization in the country, and I am also a criminal defense lawyer. Almost 7 years to the day, the Supreme Court of Canada released R.V. Noor, a decision where the court, for the first time in 30 years, struck down a mandatory minimum sentence. I had the privilege of being counsel for Mr. Noor at the Supreme Court, and I have worked on several challenges to mandatory minimum sentences since then. I come before the Standing Committee today with the benefit of litigating these challenges and with the stories of my clients who actually faced the mandatory minimum sentences that Bill C-5 would repeal. And there is one particular story that I want to share today. It is the story of my youthful client who, with no criminal record, walked into a convenience store holding a BB gun he bought from Canadian Tire previously, showed it to the store clerk, and stole $100. He was an alcoholic at the time and extremely drunk when he committed the offense. He used the $100 to buy even more beer. He was caught within a couple of hours and immediately confessed. In the time between his arrest and his sentencing, he completely turned his life around. He enrolled in university, got into a relationship, regularly attended Alcoholics Anonymous, became a facilitator for Alcoholics Anonymous, and the last sip of alcohol he had was the day he committed the offense. This client, this real person, received a 12-month jail sentence because that's what the mandatory minimum sentence demanded. No one in that courtroom, not the lawyers, not the judge, not the court staff who heard his story, thought that this person should go to jail for 12 months, stripped from the pro-social life he had developed only to be locked up in a jail cell. But they had no discretion, no choice. In the trial judge's words, it was heartbreaking to send this person to jail, but she had no choice. What Bill C-5 would do is introduce discretion into the criminal justice system again. The discretion to consider the circumstances surrounding the offense, the moral blameworthiness of the offender, and to ask what sentence does this person actually deserve. I also come before the Standing Committee today as a director of the South Asian Bar Association and as a racialized lawyer who represents racialized accused. When I walk into a courtroom or a jail and look at the faces of the accused I see, they resemble my own. They are so often racialized. And the empirical evidence backs up my lived experience. Study after study has revealed that Canada has a problem with the overrepresentation of Indigenous and Black offenders in jail. If this problem of overrepresentation matters to us as a country, then we need legislation like Bill C-5. We need to give trial judges the discretion to let people serve their sentences in the community or to shorten their jail sentence to only what's necessary. Without such discretion, judges don't have the ability to consider the systemic factors that contribute to the commission of crime: colonial legacy, residential schools, poverty, over-policing of certain communities. Bill C-5 is not about being soft on crime. Offenders who deserve long jail sentences will continue to get those sentences. Bill C-5 is about proportionality and about giving judges the discretion they need to ensure justice is done. Thank you again for the opportunity to present today.
Thank you, Ms. Shamnagunathan. I'll next go to our first round of questions, and beginning by Mr. Moore for 6 minutes.
Well, thank you, Mr. Chair, and thank you to our witnesses and for the testimony that you've provided. And it is good to see some of our witnesses here in person because that's a first for our committee. So hope to see more of that in the future for sure. You know, we heard the characterization of Bill C-5 is some offenders just need an opportunity to give back to their community. And I can tell you, as someone that was involved in the drafting of Bill C-9, which ended the practice of giving conditional sentences like house arrest for serious crimes like criminal negligence causing death, manslaughter, impaired driving causing death, aggravated assault, aggravated sexual assault with a weapon, kidnapping, and torture. These are serious offenses. To pretend that somehow someone who's committed these offenses should immediately be given a chance to be back into the community so they can give back is absolutely ridiculous. Every case before a judge is different, and every one of them brings their own unique challenges. But the mandatory minimum penalties and house arrest have their place. But on serious offenses, we need to make sure that our communities are protected and that offenders can get the help that they need. Using a firearm in the commission of an offense, weapons trafficking, robbery with a firearm, extortion with a firearm. These are things that we hear about every day as parliamentarians. We hear about gun violence. These are currently offenses that require, if someone's found guilty, that they would serve jail time, and as they should. And this bill would end that. And obviously, it's a concern for, it should be a concern for all Canadians, whether they live in rural or urban areas. as I mentioned, as Parliamentary Secretary to the Minister of Justice at that time, I was happy to work with organizations like MAD Canada, who supported Bill C-9, and they're looking at these offenses from the perspective of the many victims that they represent, as well as protecting Canadians from impaired driving. It's hard to believe, in fact, in my opinion, that we're back here discussing some of these after the hard work that went into correcting the imbalance in our justice system. And I will pose my question to MAD Canada. Could you tell us a bit how the legislation from 2007 impacted victims of impaired driving, and why victims of impaired driving and their families were calling on changes to the legislation as it was?
Thank you, Mr. Chair. As we mentioned, MAD Canada was very much involved in the discussion and debates around Bill C-9 back in 2007. And we brought the message of the families that we work with, that we support, who had lost a loved one or multiple loved ones, that house arrest and conditional sentences was not appropriate for impaired driving causing death. We have seen sentences increase generally over that time, and I think it's important that the courts have recognized the essential message that needs to be sent in terms of denunciation and deterrence. But the idea that for the families that we support, that we could step back and possibly allow conditional sentences for impaired driving causing death is hurtful and harmful to many of them, and they feel it could re-victimize them.
Thank you, Mr. Sullivan. Your brief, you stated that many of the individuals that MAD Canada works with feel that sentences for impaired driving related deaths do not reflect the harm that has been caused. In a letter to the Prime Minister in September 2020, you stated that in too many cases we are the only support victims and survivors have. And we've heard that at this Justice Committee about the need for support for victims and their families. As impaired driving is often not a priority for government-funded victim services, could you share what, if any, consultation MAD Canada has had with the federal government on Bill C-5? Because I know you were consulted widely on Bill C-9 when some of these changes were first put into effect, and these are changes that are going to impact the families of victims of impaired driving, and they're changes that are going to put impaired drivers, rather than in jail, back on the street. So could you share consultations that you've had with the federal government on this?
We did have an opportunity to discuss the previous bill, Bill C-22, I believe, with department officials, and we met with the then Parliamentary Secretary to the Minister of Justice and expressed exactly the same sentiment we're expressing here today.
Okay, I only have 1 minute left. Time flies. But, well, look, we appreciate the work that you're doing, because you bring forward the perspective of victims and their families. And it's important for us as parliamentarians that the criminal code reflects Canadian values, and also a balance in our justice system that treats everyone fairly. But I always like to err on the side of protecting our communities and victims, and listening to the concerns that victims who are no longer with us, the concerns that their families have. You stated that victims and survivors should not be sacrificed to safely return offenders to the community, and that you believe the well-being of victims and survivors should be balanced with the safe integration of offenders. And I think most of us support the safe integration of offenders. How do you, could you expand on that a bit, how you reconcile those two things?
Sure. I mean, I think all of the folks that we work with appreciate that at some point individuals will come back to their communities, and their number one concern is that people do not recommit and harm another family. So, you know, we support people changing rehabilitation, but at the same time, those decisions can impact people who've been most affected by the crime. And we just want to make sure, whether it's a parole decision or probation, that we take into consideration their concerns and their needs as well.
Thank you.
Thank you, Mr. Moore. Now over to you, Ms. Dillon, for 6 minutes.
Thank you, Mr. Chair. My questions will be directed to Ms. Shan Muganathan. I'd like to first start with something we've been seeing more and more of, which is the overrepresentation of people of color and Indigenous people in the criminal justice system. Can you please talk to us about the impact of mandatory minimum sentences, how they've impacted these communities and communities who come from financially disadvantaged backgrounds? Thank you.
Yes, thank you for the question. So, mandatory minimum sentences, what they do is they handcuff the ability of a trial judge to give what they feel is the appropriate sentence for a particular offender. And what we know from the empirical evidence is that members of racialized communities are overrepresented in the criminal justice system. They are arrested disproportionate to their representation in their community. They're convicted, they're sentenced for longer periods of time. And so what mandatory minimum sentences do is they force judges to send these particular members of the community to jail, even where outside the mandatory minimum sentence, they wouldn't have to go to jail. And the reality is that these members of these marginalized communities, they may not have the resources to fight mandatory minimum sentences, the challenges in the courts, so they end up getting a sentence that they otherwise would not have received. And so Bill C-5, through introducing discretion to trial judges, will hopefully alleviate the problem of overrepresentation.
Perfect. And we've seen minimum sentences have been in place for over a generation. And do you find they've had an impact in general, or they've really harmed marginalized, racialized communities, in your opinion?
So I can only speak based on the experience that I have representing certain communities and based on my review of the empirical evidence. And what we see is the empirical evidence shows that mandatory minimum sentences don't deter crime. Simply having a mandatory minimum sentence in the book doesn't mean that a prospective offender is going to see that minimum and then decide not to commit the offense. The things that are going to actually help alleviate crime is investing in resources in the community, like addressing issues of poverty and over-policing and those kinds of systemic issues. And so if mandatory minimum sentences don't deter crime, the harm that they produce, in my view, is disproportionate, which is we just send people who shouldn't be going to jail for long periods of time to those long periods of time.
Perfect. And opinion, what are some of the impacts of somebody who receives mandatory minimum sentences and it's their first offense, it's the first time they're being sentenced to sometimes harsh sentences? Can you talk to us a little bit about that, how it impacts them as a member of society?
Sure. I mean, it's the impact generally of sending a person to jail. And in the story that outlined this person who is a youthful offender with no criminal record who essentially rehabilitated himself, has become a pro-social member of society, is suddenly stripped from his life, his family, his friends, his job, his Alcoholics Anonymous meetings, and is put into a jail cell for 12 months. And so stripping this pro-social person away from the community and making them serve a jail sentence simply because it's a jail sentence that the code requires is not good for him, and it's not good for society as a whole.
Okay. And in your opinion, those who come from, disadvantaged backgrounds, can mandatory minimum sentences force them to relinquish their rights to have themselves heard in court because they don't have adequate resources or legal representation? They're not given the same equal treatment that they should be?
So the danger of a mandatory minimum sentence is that it can be, it can act like an incentive where if a person is charged with an offense and they're facing a mandatory minimum sentence if they're convicted of the offense, but if they were to plead guilty to a lesser offense and not have to face that mandatory minimum sentence, it incentivizes a person to plead guilty to an offense even if they're not guilty of the offense, even if the Crown can't prove the offense, they're incentivized to plead guilty just to avoid that mandatory minimum sentence. And unfortunately, many of our accused who go through the criminal justice system don't always have the benefit of counsel, and they make these decisions on a cost-benefit analysis. And if they say, well, if I just plead guilty to this, I don't have to go to jail for 12 months, they may very well do that.
Oftentimes we see that. I thank you so much for your time and coming here to testify and the work you're doing to raise awareness.
Thank you, Ms. Dillon.
Thank you.
Now we'll over to Mr. Fortin.
Merci, Monsieur le Président. Je vais continuer avec Madame Giannini, si vous permettez. J'écoutais attentivement votre témoignage et ce que j'en comprends
Is it
des
just me or I'm
dernières...
not hearing interpretation?
Can you hear the interpretation? Testing the interpretation. I hope my time can start over, Mr. Chair. Thank you. So, good afternoon, Ms. Shan McGannaton. I listened with interest to your testimony, and at the end you said the problem with mandatory minimums is that racialized people have fewer resources to defend themselves, to hire a lawyer, for example. And many of them are incentivized to plead guilty in order to save money and then may end up in prison rather than something else. So am I to understand that the real problem is actually the funding of legal services for these people? Or do you believe that in these cases, because some people have fewer resources, that, you know, we need to deal differently with them? What do you mean exactly?
Sure. So thank you for the question. So I'm not, this is not a resource problem. The danger and the incentive that mandatory minimum sentences create is something that affects every accused person when they're engaging in the cost-benefit analysis of, do I take a matter to trial because I am not guilty of the offense? Or do I just resolve the matter in some way so I don't risk having to go to jail for a mandatory period of time? The problem becomes exacerbated in among accused people that belong to certain communities because members of those communities, because of issues with poverty, may not have adequate supports or adequate resources or adequate advice to make those types of decisions. So it is not uniquely a problem of resources. It is a problem that mandatory minimum sentences create for all accused, the incentive to plead guilty to a different offense.
La solution...
So the solution would be to better fund legal services, if I've understood correctly, to ensure that anyone who is accused could benefit from the services of a lawyer. You know, I always have trouble, you know, when people say racialized people, you know, we can't impose any mandatory minimums on racialized people. You know, I don't know if that argument holds up. You can be for or against mandatory minimums, but I think that the same logic should apply to everyone. And I don't think people should claim that racialized people have any particular behavior that would lead them before the courts more often than anyone else. So my question would be this. Would you agree with me that if we look at all mandatory minimums that are currently applicable, if some of them could be abolished, maybe some should also remain? Or, in your opinion, do you believe that all mandatory minimums, regardless of what they're for, armed robbery, murder, etc., do you think that there shouldn't be any mandatory minimums at all?
So if I could just clarify my earlier submissions, if I've led this committee to believe that I think mandatory minimum sentences should be abolished only for members of the racialized community, that is certainly not my submission. The submission is that mandatory minimum sentences should be repealed because they affect members of all communities, not just those among the racialized ones. In terms of abolishing mandatory minimum sentences, my submission would be that whatever Parliament can do to introduce discretion into the hands of the judges who hear the background information about the offender, who understand why a person committed the offense, and leave them with the responsibility of ensuring that the sentence that they impose on that offender is proportionate to the offense and the offender. That is what is going to make our justice system a better place for everyone involved. And that includes both the offender, the judge, and the victim.
Pour toutes les offenses?
For all offenses? Or do you think that some offenses should have mandatory minimums maintained?
My submission would be, and this is just me based on my experience in the criminal justice system, is that what we've seen from the literature that's developed on mandatory minimum sentences, as well as the decisions on these court cases, is that judges don't need mandatory minimum sentences. If they feel that an offender needs to go to jail for a particular period of time, they can impose that sentence regardless of the existence of a mandatory minimum.
Je suis d'accord avec vous, mais en tant que...
I agree with that. You know, as a legislator, people say, you know, when you're getting rid of mandatory minimums, it sometimes sends a concerning message. You know, like you, I do have confidence that judges will be able to impose appropriate sentences, whether or not there are mandatory minimums. I agree on that. But doesn't it send sort of a concerning message to people when we say we're going to abolish all mandatory minimums? Is that not a message that sort of implies that some of these offenses are less serious than you might think?
I think the message that it sends the public and the people we should be concerned about is the informed public. The message that it sends the informed public is that we trust trial judges to do their job. These are people that are qualified to be in the positions that they're in. They're going to do their jobs appropriately. And if they feel that a person needs to go to jail for a certain period of time, we can trust them to do their job.
Merci, Madame.
Thank you very much.
Thank you, Monsieur Fortin. Now to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I thank all the witnesses for being with us today when we're dealing with such an important bill. I want to start with Ms. Shanmugam and ask a question that backs up, I guess, a step. When she's talking about the impacts of mandatory minimums on the racialized community, when it comes to drug offenses, I guess the point that I've been pursuing is, why are we talking about mandatory minimums rather than actually removing personal possession of small amounts of drugs from the criminal code as a criminal offense? And wouldn't that have a larger effect on the racialized communities in Canada?
I think it will certainly have an impact, and I just want to sort of stay in my lane, and we're talking about mandatory minimum sentences, so I certainly invite the committee to consider other options and other ways of eliminating or help alleviate the overrepresentation problem, but at the bare minimum, removing mandatory minimum sentences would also have some effect.
Thank you, Ms. Shanmugam. I think you're technically correct about staying in your lane, but we're also talking about ways to attack systemic racism within the justice system, and so I think we have to keep our eye on that larger court of play as well when we're talking about this bill. I want to turn to the Canadian Bar Association and talk about one of the things that was said as part of your presentation. I'm sorry, I forget which of the two of you said it, but you talked about mandatory minimums resulting in, the phrase I think was used was warehousing until release. And so my background is in criminal justice, and I know we have often seen short sentences in the area of 1 to 2 years, resulting in no rehabilitation because of a lack of resources within the provincial and federal correction systems. So is this what you're referring to in that very brief statement?
Mr. Chair, if I could answer Mr. Garrison's question. Mandatory minimum sentences are generally less than 2 years, which means that any offender who is sentenced to that period of time will spend it in a provincial jail. Conditional sentences must, by definition, be less than 2 years. So in effect, some of these mandatory minimum sentences, which are passed by federal legislation, put a substantial burden on the provincial jail system. And that system isn't able to deliver the kind of programming, number one, because they don't have the resources, but number two, people aren't in a place long enough that they can become entrenched in a program and see it through to its completion. A much better alternative is to allow offenders to serve their sentences, nonviolent offenders, obviously, in the community. They begin their sentence with a conditional sentence, which could include a period of house arrest, but also treatment. Their sentence, because it would be less than 2 years, can be followed by a period of probation of up to 3 years. So in effect, that person has the ability to receive 5 years of supervision and access to rehabilitative programming. And so eliminating these mandatory minimum sentences is a first step to seeing people receive better, longer, more involved treatment and emerge from the system rehabilitated, as opposed to being warehoused until they can be released.
And of course, the result of that is greater public safety. When you talk about burden on systems, I want to continue perhaps with you, Mr. Burks. Can you talk a bit about the problem we have with delays in the criminal justice system and the impact of the existence of mandatory minimums on those delays?
Mr. Chair, Mr. Garrison raises a very important issue. Normally speaking, and I've been doing this for over 20 years, I have clients that come to me all the time and say, look, you know what? I did it. I want to accept responsibility for my actions, and I want to receive my sentence. And I facilitate that. The problem with mandatory minimum sentences is it disincentivizes early pleadings. Someone who can receive an appropriate disposition, oftentimes that both the Crown and the defense agree upon, that is non-incarceratory, there is a large incentive for them to plead early on in the process. If there is a mandatory minimum involved, the cases languish in the process, pretrial motions are brought, a lot of resources are spent defending that in the effort to try and escape a conviction because it would end up with a mandatory minimum. If you remove these mandatory minimums and make alternative sentences available, people generally will resolve their matters early on in the process, freeing up valuable resources with respect to much more serious offenses. Now, those serious offenses have to wait in the background while resources are spent on these mandatory minimums. And the problem is if things languish too long, the Jordan decision gets involved and matters are thrown out for delay. Thank you.
And so if we proceed with C5 as it's written, we could expect within a fairly short time a major impact on delays in dealing with more serious cases in the court system. Is that correct?
Any piece of legislation that encourages people to resolve their cases for just dispositions will free up resources, and over time we will see a faster justice system, which is beneficial both to accused, to victims, and to the system in general.
Thank you very much.
Thank you, Mr. Garrison. And now to Mr. Morrison for 5 minutes.
Thank you, Chair. And thank for the witnesses for coming today. Sometimes when we talk about offenses and offenders, I don't think we ever forget the victims, but sometimes the victims' rights are not really at the forefront of when it gets to sentencing. And I think I'm going to just ask one question from either Eric or Steve. Just if you have spoken with victims, and especially about C5, have you spoken specifically with victims that how do they feel if in fact C5 repeals mandatory minimums for impaired driving causing death?
I speak to victims and survivors every day, and just so to clarify, it's not repealing mandatory minimums for impaired driving, it's just expanding the ability of judges to impose conditional sentences for a wider variety of offenses, including impaired driving causing death. Talk to families, from years ago who may still work with us where conditional sentences were handed down. And in more recent times, just talked to families about some of the things we're involved with and talked about the possibility of conditional sentences being reintroduced. Many are shocked. Those people we work with today can't imagine a time when a conditional sentence was given for an impaired driving causing death. And so the families that we talked to today about it are just, I don't even know what the words are, just shocked that that could be a possible sentence for someone who's by a decision of their own caused the death of someone else.
Okay, thank you. And I just want to ask a question to the Canadian Bar. And I think, Jody, I think you're the one who was talking, or both actually, Tony and Jody, you're talking about nonviolent. That, you could see the, not the mandatory minimums being removed from nonviolent, but I guess that would mean you don't agree with robbery with a firearm, extortion with a firearm, discharging a firearm with intent. I mean, that just, all the firearm offenses, to me, are pretty violent. Even when we get into the expansion of conditional sentencing, there's some of those that are kidnapping. Would you not consider that violent? Abduction of a person under 14. Imagine telling the parents of that individual that, oh yeah, we're going to CSO because we were reducing some mandatory minimums. I just wonder if you do agree that some of these offenses that are listed in C5 should remain because they are violent, and that, in fact, the C5 could be amended.
So I'll take this question, Chair. One of the problems that I think surrounds this debate is that the focus remains on the black letter wording of an offense as opposed to the circumstances in which it's committed. And what I mean by that is, take robbery with a firearm, for example. When people say that, what comes to mind immediately is the person with the gun in their hand and they're holding up the bank. What doesn't come to mind is the drug-addled assistant to the robber who is driving the car and has an idea or is willfully blind to the fact that someone is going to go into a store with a weapon. Is that person the same circumstance as the person holding the weapon? Clearly not. But they're going to be treated the same under a mandatory minimum because one is a party and one is a principal, and under the law, those things are the same. And so when we speak of offenses in the singular terms of how they're written down in the law, we lose sight of the fact that they can be done in a wide variety of circumstances. And when we think about conditional sentences, that's particularly important. So think about drug importing. We all think of the major drug trafficker that brings kilos and kilos into the country. We don't think of Cheyenne Sharma, the appellant in the Sharma case before the Supreme Court of Canada, who was raped at 13, a sex worker at 15, and was trying to feed her family by taking on a task at the behest of someone who was exploiting her. So in my respectful view, it is overly simplistic to look to just the name of the offense and close the book. What we have to think about is not just the offense,
and
but
thank
what
you for
happened.
that. I just have a short time. And I do agree in some cases, robbery with a firearm, but when you look at a victim who doesn't know the difference between a pellet gun and a 9mm or a 45 caliber, I find that a little hard to imagine that we are going to remove mandatory minimums because somebody couldn't identify whether it was a pellet gun. And let's talk about drug offenses, production of crystal meth. Like, how can possibly someone say that, yeah, go ahead and produce it, and you know what, let's remove mandatory prison for drug dealers? We have an opioid crisis on our hands in Canada. If we start dealing with removing mandatory minimums for trafficking and what you're talking about, what are we saying now to the victims and to the people we should be helping? Do you not agree that maybe we should be spending way more time on crime prevention, not crime reduction? I do agree with you. Putting people in jail isn't exactly the answer. But
Unfortunately, we're out of time,
We're out of
Mr.
money.
Morris.
Okay, thank you,
Sorry about that. Next, I'll go to Mr. Nakvi for 5 minutes.
Thank you very much, Mr. Chair. And I'm going to go back to Mr. Paisana to talk a little bit more about conditional sentence orders. And perhaps just so that we are all understanding from the same foundation, describe to us your understanding of some of the key features or elements about CSOs. What makes them unique? Why you think they are an important tool to have within the criminal code?
The conditional sentence order was an elegant solution introduced by Parliament in the 1990s to address the problem of over-incarceration. And why it was elegant is it was a scalpel instead of the sledgehammer of jail. And what it did is that it tailored a sentencing option to people who were, first of all, non-dangerous, second of all, who could be properly managed in the community, third of all, who committed offense deserving of less than 2 years in jail, and fourth of all, an offense which the deterrence and denunciation requirement could be addressed by a community sentence. And why that was an incredibly innovative and important progress in the law is because it addressed a subsection of offenders who had committed a mistake, who had done something terrible in their lives, but had a great prospect of rehabilitation. And it is the kind of thoughtful, insightful criminal law policy that distinguishes us from other jurisdictions like our neighbors to the south, who take a much more sledgehammer approach as to a scalpel approach that I think is more appropriate to our system.
Can you speak to the impact on our criminal justice system, in particular, people within the criminal justice system, by non-application of CSO, by non-use of CSO? What have you seen in your practice and heard from other colleagues within the Canadian Bar Association?
So you see two important knock-on effects as a result of CSOs not being available. The first is the obvious one that you've heard a lot about today. People who would otherwise properly serve their sentence in the community and rehabilitate are forced into the jail system, where I don't think it's any real debate that they're not going to rehabilitate to the extent they would in the community. But you also see the opposite end of the spectrum. What you see is that individuals are getting suspended sentences instead of the more harsh version of a sentence in the form of a conditional sentence, because the parties that are litigating and the judges that hear the cases realize it would be completely unjust to send the person to jail, and they're only left with one other alternative, simple probation. And rather than unjustly send the person to jail, they give them something less than a conditional sentence and probation. And that doesn't do anything for the administration of justice either. So when we take away the discretion of this elegant middle option, what we're really doing is forcing people to go to one end of the spectrum or the other and avoiding the obvious answer, which lies in the middle and is often the conditional sentence.
Can you further speak to the impact on Indigenous, Black, and people of color by not having CSOs available within the toolkit in our criminal justice system?
This is one of the great ironies of Bill C-10 taking away conditional sentences, is that the conditional sentence was introduced primarily in response to the problem of over-incarceration in the 1990s of Indigenous and other marginalized communities. And in the 25 years since, that problem has only exacerbated itself and gotten worse with these restrictions being put on CSOs. And so the very purpose of this thing was to give the system greater restraint and a greater tool set in order to deal with communities that are overrepresented. And by removing it, we have simply exacerbated the problem, in my view.
So if Bill C-5 is passed into law, what opportunity do you see as it relates to CSOs being available as a way of sentencing?
What it will do is it will significantly expand the eligibility of offenses for which we don't really think about when we think about violent offenders. The scope of offenses that is captured by the current prohibitions against CSOs is staggering. It includes things like forging a passport, contraventions of the Competition Act, other offenses that one does not associate with the serious offending that it was said to be targeted towards. And so what it will do is it will unlock CSOs for a number of offenses where it is appropriate. And again, I reiterate what I said earlier today, which is this is only about giving more discretion, not less. And if jail is appropriate, be it under 2 years or over 2 years, that discretion will remain all the same. And that includes offenses like drinking, driving, causing death. That's an offense where the range of sentence across this country is in the years and sometimes double digits for that kind of offending.
Thank you. My time is up. Really appreciate your participation.
Thank you, Mr. Naqvi. Next to Mr. Fortin for 2.5 minutes.
Merci, Monsieur le Président.
Thank you, Chair. My question will be for Jody Burks from the Canadian Bar Association. I mainly agree that mandatory minimums don't really help deal with cases that end up before the courts sometimes. But I also think that as a legislator, we send messages to the public when we repeal laws or modify them. We've been doing this since Confederation or even earlier, and it will probably always be that way. And I think that legislation needs to adapt to the societal reality. So it needs to be a tool that really serves the people that we represent. But recently, we've seen a real skyrocketing of violence in some regions of Canada. My colleague was talking about the opioid crisis in his writing. We've seen that in my writing as well. We've also seen increased firearms violence. And I've heard from others who said, I'm afraid to send my kids to school because there are firearms circulating in some of those schools. So our constituents are asking us to take action on this. We're doing our best. We're calling for new joint squads to deal with firearms violence, for example. But now the idea of eliminating mandatory minimums, Mr. Birks, I heard you say in your testimony that, you would make an exception for murder. So I want to know if you think we shouldn't be distinguishing between some crimes. When you talk about abolishing mandatory minimums, we also need to reflect the reality of the year 2022 that we live in, as opposed to the reality of the 90s or of the future. In this year, 2022, people are very concerned about firearms violence. Should we not be prudent when it comes to abolishing some of these mandatory minimums?
Thank you, Mr. Chair. Mr. Fortin raises a very important point, that the members of the public that he serves and that all of the lawyers involved in the criminal justice system serve are aware of the public perception of what we do. And the answer is, if we eliminate certain mandatory minimums, or as the CBA recommends, all mandatory minimums except for murder, it doesn't mean that people who don't need to go to jail to serve denunciation of their conduct using firearms in a violent way won't end up in jail. They will end up in jail. The fact that violent crime is on the rise while we have these mandatory minimums on the books is self-evident that they don't work to deter that kind of crime. What we need is more enforcement. Sorry.
No worries. Thank you, Mr. Birks. We'll try to hopefully vote him. Next, Mr. Garrison for 2.5 minutes.
Well, thank you very much, Mr. Chair. I want to go back to Mr. Paisana and his comments on the application of CSOs in the cases of drunk driving causing death or bodily harm. And you quickly passed over the normal sentences for those. And so I'm drawing a conclusion. What you said is that the change we would make if we pass C5 in its current form would have relatively little effect on cases of drunk driving causing death, because the sentence is almost always more than 2 years. Is that correct?
That's correct. The range in sentences for that offense across the country in courts of appeal is in the multiple single digits, and sometimes, depending on the circumstances, double digits. It's not uncommon to see 6, 8, 10-year sentences. Of course, there was the famous Humboldt case that resulted in an 8-year sentence, for example.
Okay. I guess I want to go back to Ms. Shanmuganathan, and I appreciate you being very clear that your expertise is in mandatory minimums. But I want to talk about another aspect of the built-in or structural racism, and that has to do with the effect of criminal records on those who have been sentenced for drug offenses. And I wonder whether the clients you deal with have seen the long-term impacts of not being able to get diversions or things that would result in no criminal record on employment, housing, and those kinds of things.
Yes, absolutely. Being stamped with a criminal record has long-lasting, lifelong effects on a person. It can hinder their ability to be gainfully employed, to get housing, to move on with their lives in some meaningful way. And so if there are mechanisms to divert people away from a criminal offense or a criminal conviction and a criminal record, it is, of course, a welcomed option.
And when you talk about housing, I know in my own community there are some social housing and supportive housing programs that you're simply not eligible for if you have a criminal record. Is this the kind of impact that you're talking about, you've seen with your clients?
Yes, absolutely. There are checks that are run on certain people in order to get housing in places, in order to get jobs. And if you become flagged as somebody with a criminal record, you're out of the running for those types of things.
I see I'm out of time. Thanks very much.
Thank you. I'll now conclude this first part of the panel and just suspend for a minute to do a quick sound check for Mr. Dr. Robert, who I think all the rest have been sound checked. So the rest of the witnesses, you're happy to stay on if you want. Otherwise, you can disconnect if you'd like. So I'll just suspend for 1 minute. For this meeting, I'm going to ask each one of you to speak for 5 minutes, each group, and then after the 5-minute rounds for each of the speaking groups, we will resume to questions. I have signs, as I've just outlined earlier, 30-second time clock, card, and then a out of time, so please be respectful of time so we can get all the members to have a question. So I'll begin by having Brandon Roll for the African Nova Scotian Justice Institute. He's a senior legal counsel for 5 minutes, and then we'll go over to the dispensary and then National Coalition Against Contraband Tobacco. So beginning with you, Brandon Roll, please.
Thank you, Mr. Chair. Good afternoon. My name is Brandon Roll. I'm senior legal counsel at the recently established African Nova Scotian Justice Institute. I'm pleased to speak today in support of Bill C-5, which we see as a necessary step towards justice. African Nova Scotians are a distinct people who descend from free and enslaved Black planters, Black loyalists, Black refugees, Maroons, and other Black people who inhabited the original 52 land-based Black communities in that part of Mi'kma'ki known as Nova Scotia. The African Nova Scotian Justice Institute is a provincially funded, but importantly, community-led infrastructure developed in response to systemic anti-Black racism faced by African Nova Scotians in the justice system. We acted as interveners in the Anderson case, a Nova Scotia Court of Appeal decision that affirmed the use of impact of race and culture assessments, or IRCAs, as a valuable sentencing tool when sentencing people of African descent, and provided a framework for applying systemic and background factors related to race and culture. There can be no serious dispute that systemic anti-Black racism exists in the criminal justice system. In RDS, a well-known Nova Scotia case that went to Supreme Court of Canada, the Supreme Court endorsed comments from another Nova Scotia case and put it very bluntly: racism is a pernicious reality. The issue of racism existing in Nova Scotia has been well documented in the Marshall Inquiry. A person would have to be stupid, complacent, or ignorant not to acknowledge its presence not only individually, but also systemically and institutionally. The evidence is also very clear that one of the ways that systemic anti-Black racism has manifested is through the over-incarceration of African Canadians. The committee has the data before it from the DOJ about the disproportionate impact of mandatory minimums on custody rates for Black people. But I would suggest there are some contextual factors we can look at that help us understand why MMPs disproportionately impact people of African descent. First, we know that Black communities are subjected to over-policing and over-surveillance. Since Black people are more likely to be arrested and charged with an offense, they're subject to a disproportionate risk of criminal liability for offenses carrying a mandatory sentence. Second, Black accused are disproportionately detained before trial. The research is increasingly clear that accused persons who have been denied bail feel greater pressure to plead guilty. Third, African Nova Scotians and African Canadians at large have experienced a legacy of slavery, colonialism, segregation, and racism that has led to this historic pattern of disadvantage, which includes overrepresentation in custody, involvement in certain offenses, being denied bail, and receiving longer jail sentences, and subsequently serving harsher time while in custody. So we submit that to truly address systemic anti-Black racism, the approach has to be multifaceted and must include the type of legislative reform being proposed by Bill C-5. But we suggest that has to be done in combinations with efforts further upstream in the justice system that address the root causes of offending behavior, which is the type of infrastructure we're trying to build here at the African Nova Scotian Justice Institute. We endorse the comments of Justice Derrick and R.V. Anderson, that case I mentioned earlier, when she was discussing this exact type of legislative reform. At that time, it was called Bill C-22, but we know that was the earlier version of this bill. And she said, I quote, "It speaks to what the Supreme Court of Canada noted in Gladue. Over-incarceration is a long-standing problem that has been many times publicly acknowledged, but never addressed in a systemic manner by Parliament. Its proposed reforms would enhance the discretionary power of judges in sentencing Black offenders. The increased availability of conditional sentence orders would afford judges greater scope in imposing sentences that better serve the principle of proportionality, thereby better serving the community and the offender with systemic factors and historical disadvantage taken into account," end quote. So we agree that MMPs do not effectively address recidivism. Longer and harsher jail sentences have been shown to actually increase recidivism, and as such, MMPs can work to decrease public safety. Mandatory minimum sentences do not accord with that fundamental sentencing principle of proportionality because they remove that discretion of the sentencing judge to consider the moral blameworthiness of the offender, and they provide no opportunity to account for not only the personal circumstances of the accused, but those systemic and background factors that may come into play. When it comes to African Nova Scotians and Black Canadians, we suggest that judicial discretion, should always be informed by tools like impact of race and culture assessments to better address overrepresentation. This type of legislative reform is an important part of the answer. It's not the complete answer, but we suggest it is a step towards substantive equality. Thank you, Mr. Chair.
Thank you, Mr. Roll. Next, we have the Dispensary Community Health Center. We have Hugo Bissonnette, Alexandra DeKewitt, and Dr. Jean Robert for 5 minutes. So you can split it up however you want.
Merci beaucoup.
Thank you very much. Well, I'm very honored to have been invited this afternoon. I'm going to speak much more from the heart today than simply from the brain. I am a doctor. I specialized in infectious diseases, but I also have a lot of experience in community health. It's been 46 years this year since I've been taking care of people. So taking care of people, not always treating them, but taking care of people who are part of a culture that has sometimes subjected them to problems such as drug addiction. Now, in the context of C5, it seems to me that there's something very concerning happening. You have the section that deals with firearms and the section that deals with drugs. Now, firearms kill other people, and drugs actually can kill the user. Firearms are a problem of public safety, and drug use is not a problem of justice, it is a problem of health. So that's something that greatly concerns me. I entirely agree with the removal of mandatory minimum sentences at long last for people who are already who treat themselves with various substances that circulate in society. So that was my first point. My second point is that people who die of drug overdoses or the consequences of drug use all have one common characteristic. And that is that they are ignorant of what is actually in those drugs. I'll give you an example. My doctor, or rather, I'm obliged to inform people of what this vial contains. Here you can see it's just a very, very small vial, and it contains heroin. It was brought to me by a drug user, and it contains other substances than heroin. And that's what kills people. It's the fact that they don't know what is laced in these drugs. And so we need to have we need to find ways to treat people. That's what I do as a doctor. And we need to make sure that drugs can't be laced with these substances. Now, the third point I wanted to make is that there are certain exemptions for simple possession, for personal use of drugs, and we absolutely should add an exemption for people such as myself and the people on my team who need to use these drugs professionally, so that people on our team who work in the streets, well, if they have to cross the street holding a little baggie of whatever powder, so that they're not worried that they will be arrested. That is the only recommendation that I want to make. Of course, there are other ideas that could be floated, but based on my 46 years of work in this context, I also worked in prisons and so on, I believe that what will save lives is being able to analyze urine samples, for example, to see what drugs people are using, and to analyze the drugs to see what they're being laced with. I think that that's the essential point. We made a request exactly 1 year ago for an exemption. We're still waiting. And with that, I'll give the floor to my colleague, Alexandra.
But I'm hoping you can answer some of your questions or make your statements in some of the questions and extract it out of there. I'll next go over to the National Coalition Against Contraband Tobacco, Rick Barnum, for 5 minutes.
Thank you, sir. Good afternoon, committee. My name is Rick Barnum, and I am the recently appointed Executive Director of the National Coalition Against Contraband Tobacco. I most recently served as Deputy Commissioner of the Ontario Provincial Police and had an over 30-year career in law enforcement. During my law enforcement career, I spent most of my time combating organized crime. I saw firsthand how lucrative the contraband tobacco trade can actually be. The Criminal Intelligence Service of Canada estimates there to be an over $12 billion cost to healthcare, lost productivity, criminal justice, and other direct costs caused by contraband tobacco and cannabis. The RCMP estimates that there are over 175 criminal gangs involved in the illicit trade of contraband tobacco. These gangs make millions of dollars a day off of contraband tobacco, which they use to fund their other illicit activities, including illegal firearms, drugs such as fentanyl, and also human trafficking. To combat this important funding source for organized crime groups, the government passed Bill C-10 in 2014, which introduced a criminal code offense for the trafficking and contraband tobacco, and also introduced a mandatory minimum penalty for the same offense. Both of these tools have been used by law enforcement across Canada since that time to dissuade individuals from participating in the contraband tobacco trade. Prior to this, many of those charged and found guilty under provincial tobacco tax laws would simply be fined, but the fines would never actually get paid. The criminal code offense and penalties associated with this offense have made trafficking with contraband tobacco less attractive for some people. However, Bill C-5 proposes to eliminate the mandatory minimum penalty for the trafficking of contraband tobacco while keeping the criminal code offense. By eliminating the mandatory minimum penalty, the government is removing a tool used by law enforcement to dissuade possible contraband tobacco traffickers. The government of late has also helped to fuel the contraband tobacco trade by continuous increases on tax on tobacco. History shows us, as also reported by the Parliamentary Budget Officer, that tax increases without action against contraband tobacco result in a larger black market that directly funds criminal gangs. This is why, by removing one of law enforcement tools, the government must add another. Firstly, the contraband tobacco trade continues to grow across Canada without concerted federal action. Illegal cigarettes manufactured mostly in Ontario can be found from British Columbia to Newfoundland. To curb the illicit trade, we recommend that the government create a contraband tobacco enforcement team within the RCMP that would help to coordinate enforcement across the provinces. Provinces like Quebec have seen great successes in such a model, where municipal and regional law enforcement have been coordinated. Secondly, further increased taxation on tobacco without action against contraband tobacco will only help to further grow the illicit trade. We recommend that the government resume a prudent approach towards tobacco taxation until contraband tobacco is addressed across the entire country. Lastly, Ontario continues to be the epicenter of contraband tobacco in Canada. 1 in 3 cigarettes purchased in the province are purchased illegally. Criminal gangs make millions of dollars every day from this illicit trade. To address this core issue, we recommend that the government partner with Ontario in taking action against contraband tobacco. By supporting law enforcement through countrywide coordination and a prudent taxation approach, the government can begin to effectively address Canada's growing contraband tobacco problem. With the removal of one law enforcement tool, the government must add another. We hope we can count on your support in taking action against contraband tobacco and also against organized crime. Thank you for your time, and I'll be happy to take any questions.
Thank you, Mr. Burnham. Now we'll go to the first round of questions. I believe it's to Mr. Lewis for 6 minutes. Or is it you? Oh, I had Brock, so I just had. Sorry, my apologies. It's to Mr. Cooper for 6 minutes. Thank you, Mr. Cooper.
Thank you, Mr. Chair. Thank you to the witnesses. I will address my questions to Mr. Barnum. You cited in your testimony the fact that since the passage of Bill C-10, adding that section of criminal code has been an important tool for law enforcement. Given your extensive background in law enforcement and tackling organized crime, I would be interested in your comments related to the mandatory minimum aspect of C-10 as it pertains to the trafficking in contraband tobacco, because we've heard a number of witnesses who simply say mandatory minimums don't work, they're ineffective, they actually increase recidivism. Is that your experience, or is it, I presume, quite to the contrary?
My experience would show that over the years, individuals that we've caught doing trafficking in contraband tobacco in significant amounts usually end up with a hefty fine the first time, usually the second time as well, and it's not until the third or fourth time do they usually end up with a small jail sentence. So it would be less than 2 years.
And so you would agree that a mandatory minimum is an important tool?
It's an important tool for law enforcement from the perspective that it gives us the opportunity to make sure that when we charge people and arrest people and do significant investigations, that there is the opportunity that they could do some jail time.
Seen the impact of that since the passage of C-10?
The investigations that we were doing were very high level. These aren't individuals that are walking down the street with a baggie of contraband tobacco. We're talking tractor trailer fulls and things of that nature. And we have seen where there is the opportunity for the individuals to go to jail, but most often it's a significant fine, sometimes $200,000 or $300,000 or more, but not jail time.
I think it's an important point that you made, that these are not people with a baggie. And it's part of the problem, I think, with this bill is that it's not as advertised. The government talks about minor possession, even though there is a directive that has been issued not to prosecute such cases. What the substance of the bill does offer is eliminating mandatory jail time for trafficking offenses, importing and exporting, production of Schedule I and Schedule II drugs. And we have, speaking of Schedule I and Schedule II drugs, an opioids crisis in Canada. 20 Canadians die a day. Could you elaborate on the connection between those who are involved in the contraband of, or the trafficking of contraband tobacco and those who are involved in perpetuating the opioids crisis in Canada?
Excellent question. There is absolutely no doubt, in my experience, firsthand lived experience, that in probably the last 10 years or so, it is not uncommon for police to do significant high-level investigations targeting contraband tobacco or targeting cocaine or methamphetamine or fentanyl, and during the course of those investigations running into significant amounts of whichever drug. But at no time, in my experience, do I see high-level organized crime groups working linearly or in a linear fashion where they just deal in contraband tobacco. So in our seizures, it's not uncommon to find cocaine, tobacco, fentanyl together, handguns, the list goes on. And as recently in 2020, Project Cairn, which was an investigation the OPP did just north of Toronto in York Region, there were 2 or 3 kilograms of cocaine, hundreds of cases of contraband tobacco, kilograms of fentanyl, handguns, and other associated type drugs that are used to break down the cocaine for sale on the street. All captured in one organized crime group in one arrest.
Much time, Chair? Okay, well, thank you for that. I'll turn the balance of my time to Dr. Robert. Dr. Robert, you spoke about issues around simple possession and personal use. But again, this bill doesn't address that. What it does do is it eliminates mandatory jail time for the producers and pushers of dangerous drugs that harm many, many Canadians. When we talk again about the opioids crisis, 20 Canadians a day dead, 7,000 a year. Are you concerned that this bill eliminates mandatory jail time for traffickers and producers and pushers? And would you not see a significant distinction between those involved in such activities versus someone who is involved in simple possession or for their personal use?
Dr. Robert, I think you're on mute.
No.
Sorry. Yes, so thank you for the question. I would say that with the numbers that you've cited, that's on the worst end. And I'm talking about people's personal use of drugs or personal consumption. And that's what we should stop punishing. We should stop punishing people for personal use. In terms of manufacturing and distributing drugs, that is more of a public safety problem, not a health problem. I would say in passing that, yes, we've focused on opioids, but almost 90% of substances sold actually contain between 2 and 18 other substances. So people talk about opioids. It's true that that's a problem, but there are also other drugs laced in them.
Mr. Cooper, and thank you, Mr. Robert. Next, over to Madame Diab for 6 minutes.
Thank you very much, Mr. Chair, and merci à tous les témoins qui sont
Thank you to all the witnesses for being with us this afternoon.
Directing my questions to Mr. Brendan Roll of the African Nova Scotian Justice Institute, and for the benefit of my colleagues, when I served in the provincial legislature, I would have had a chance to meet Mr. Roll, and am familiar with a number of the initiatives that have been undertaken in Nova Scotia to combat the systemic racism that I believe Nova Scotians and it's well documented in our system. So really grateful that you're here with us to share your experience and expertise with our committee today. And I understand, Mr. Roll, that you recently met with the Justice Minister when he was in Nova Scotia, I think a couple of weeks ago. Can you share with the committee whether or not you would have spoken about this bill and sort of what you would have shared with him? And I would also then direct you to be as blunt as you obviously need to be. And with us, the use of mandatory minimums and the restrictions on conditional sentencing orders, which is the two that we're talking about today, and the effect on the features of racism in our justice system from your experience and your expertise.
Thank you for the question. So one of the arguments that we put forward in Anderson that I think it's important to remember is that the law itself has been used as a tool to oppress people of African descent, and particularly African Nova Scotians, for centuries. This is obviously a complex problem that doesn't just reside in justice, but we do need a justice response because in part this is a justice problem. So when Minister Lametti visited Nova Scotia, we talked primarily about the work being done with impact of race and culture assessments, which is connected to this debate, because by allowing more community-based sentences, we can actually allow some of that work that gets at root causes to take place. And so an impact of race and culture assessment looks at that historical context of that specific community, how the person came to be before the court, connected to some of those systemic factors, and then presents rehabilitative options that are culturally appropriate. And by keeping this punitive regime of mandatory minimum penalties, we're taking that discretion away from judges to provide that sort of culturally specific programming that's needed to get at root causes. If the idea is that mandatory minimum penalties somehow send the message that it's going to decrease recidivism, I think the decades of research have shown that that's not the case. And so we need to get at the root causes to really address the problem. And that's the work that we're trying to do at the Institute. We also have to recognize that sentencing is at the end of the process, right? So we need to infuse that throughout the process, looking at police discretion, Crown discretion, and those are the sorts of supports that we want to implement at the Institute, bail supervision programs, reintegration programs, so that people are fully reintegrated in a way that's beneficial to community safety. And so that's some of the work that we're trying to do. And racism is pervasive in the justice system. I think that's clear, and the response has to be multifaceted, as I said in my opening statement.
So in your opinion, do you believe that this bill will reduce the incarceration of Black Nova Scotians or Black Canadians in the jail systems? And
thank you. I think as people have previously testified, serious offenders will still go to jail. But what it does is give judges the opportunity to impose sentences that are community-based for those who don't need to go to jail. And in particular, we know that when you go to jail as a Black person, you're not going to have culturally informed programming. You're going to be deemed a troublemaker more often. You're going to be classified at a higher risk. And so you're not going to come out of that situation in a place to successfully reintegrate into the community. That process of reintegration should start immediately upon entering the custodial setting. So not having those programs in place points to the need for the community-based resources that are going to have more of an impact in rehabilitation. And I think that's got to be the answer.
So can you speak to me a little bit more about the conditional sentencing? It requires an offender have a home, have some support. Can you speak to me about the elimination of that, I guess, if this bill does not go through, or what, the consequences that you would see on a young black male, or even a female for that matter, of having that taken away from them in appropriate circumstances?
Maybe the best way to give you an example is that Anderson case. Was a young black man pulled over at a random check stop with a prohibited firearm. He had members in his community around him that were dying through gun violence, and he armed himself, not to commit some substantive offenses, but to protect himself. And so the judge in that case called evidence in from someone who worked in corrections to say, what's available in corrections right now if I were to send this young man to jail? And the corrections officer gave evidence that there was nothing available in terms of programming. And then by contrast, she also called in members from the community to say what's available, and they were able to present a couple of options in terms of counseling, education, those sorts of programs that were going to assist him in the community. So without that particular MMP had already been struck down, but in the absence of that, that's someone who would have gone to jail, not received the culturally appropriate treatment that was required in that case, and would have had a worse outcome, and that would not, again, have been helpful to public safety, in my respectful opinion.
So thank you very much for that, and that brings me to my time. So thank you very much.
Thank you, Madame Diab. Now to Mr. Fortin for 6 minutes.
Merci, Monsieur le Président.
Thank you, Chair. I'll address my questions to Ms. Robert and his colleague. I understand, Dr. Robert, that you would be in favor of some of the measures included in Section 10, saying that if an individual arrives with a certain amount of drugs, that wouldn't constitute trafficking, and that person could be redirected towards some organization that would help them or treat their drug dependency as a health issue rather than as a justice issue. I would understand that you agree with that. If not, please correct me. But I'd also like you to speak more specifically about what you said in your testimony. You said what we don't find in the bill is an exemption for professionals who might have to touch or carry drugs in their work, not to consume it or to traffic it, of course, but simply because they are working with drug users who have addiction problems. So I'm not sure if I've perfectly understood your proposal, but I'd like you to talk more specifically about that. So the situation we're thinking of specifically is for people who don't have the support of their profession to be able to treat drug users who want to stop suffering. But of course, there are other professionals, such as social workers and psychologists, who work with us, and people who work in the streets who come into direct contact with drug users on the site. And it's really because we have confidence in them that they are able to bring us drug samples where we can, so that we can analyze them, and so that we can then get information that will allow us to prevent injury and death. And certainly, these people are very, very concerned about being arrested. So the idea would be to recognize that there are professionals, not just doctors, but people who work with drug users in the streets, for them to feel protected under some sort of Good Samaritan Act, for example. And now you've been practicing for many years, as you said. I won't betray your age, but I'm sure you've been around for a while. So what is the scale of this? How often does it happen that a social worker or someone who works in the street would have to touch or carry drugs for some other reason than consuming them, obviously, but would have to do that in order to help? Well, I think you've understood that these people feel threatened. And what they're hearing from the people they know, from society, is, oh, aren't you worried about getting arrested? I myself have experienced stigma around working in this industry. People ask me, oh, you work with those people? So that's a kind of stigma. Thank you, Dr. Robert. And I'd like to ask a question to Ms. de Kiewit, your colleague. Earlier, the doctor was speaking about people who treat their problems with drugs. And what I understand by that is that some people have addictions, and they also have underlying health problems. So they're sort of using drugs to treat themselves. I'm not quite sure how I should interpret that, but maybe with my 2 minutes remaining, you could clarify that a little bit for us. Thank you. Yes, so there are a number of reasons that people consume drugs. I have been working in the sector for more than 10 years. I work on the front lines, on the streets too. I came from a good family. I went to university, but I also was a drug user in the past, and I still occasionally use drugs. And I know people who might start taking drugs, painkillers, for example, after an accident. But, when you go to the hospital and you have pain, if people know that you've previously taken painkillers or other drugs, you often can't be given the painkillers that you need just to stay comfortable. So often people go to the hospital not just to detox, but to deal with an actual urgent health problem or an underlying health problem. And that's often when people turn to the black market because they can't get prescription painkillers and they need something to get through so that they can keep working and keep living their lives without pain. Briefly, we just have a few seconds left, but if someone were to be arrested with a small amount of drugs and if they were then brought before the courts, what effect would that have on their health? Well, a lot of health effects, certainly, but I myself have a criminal record due to this, which cuts me off from a lot of opportunities. Even though I've been working hard and sitting on many boards for the past 10 years, I've been trying to give back to my community. But, and in terms of health, certainly we're all in danger from the opioid crisis. One of my friends just died recently because she had to go buy painkillers on the black market. Thank you.
Mr. Fortin, over to you, Mr. Garrison, for 6 minutes.
Thank you very much, Mr. Chair. I'd like to stay with Ms. de Kiewit for a moment. We're talking about Bill C-5 here, but we have another bill before Parliament. It's a private member's bill, C-216, which proposes to not take away mandatory minimums, but take away possessions for personal possession of drugs and to establish a regime for safe supply. And so I don't know whether you've actually seen the bill, but my question to you is an obvious question. In order to attack the crisis, the opioid crisis, don't we need a lot more than what's in Bill C-5?
We do. I'm actually in the National Safe Supply Community of Practice. I'm part of it as a people who use drug member. En effet, nous avons vraiment...
So, yes, we need a lot more than what's in this bill. We need a whole range of practices and policies to stop criminalizing people who use drugs, because it's the people who are being criminalized here. And, it could be your mother, father, brother, sister. It could be a lot of people. Often what you see in the media is, a homeless person or somebody who has major life problems. But, I'm someone who works and contributes to society and occasionally uses heroin. And I'm also at the risk of overdose. And so there are more measures needed to protect everyone.
Thank you. I know we're getting very, very short of time today. I want to go back to Mr. Roll for just a moment. In C5, there's an increase in discretion for police and prosecutors on how they proceed with cases of personal possession of small amounts of drugs. And I'm just wondering, given the existence of systemic racism in the system and the absence of serious police reform, do you have any concerns about this increase in discretion and how it will be applied?
Thank you. I do think that's an area for growth. Accountability becomes important when we talk about use of discretion. So the fact that keeping that data is optional, can be seen as problematic. I think it's a step forward, but perhaps not far enough. The corresponding question becomes who then has access to that data when we talk about the use of police referrals or warnings. And so, I'd love to see a national framework on disaggregated data, race-based data collection that may be beyond the scope of this bill. But yes, that is a concern. The use of police discretion, the use of Crown discretion, those are two of the biggest sources of power in the justice system. And I think we do need some accountability mechanisms when we look into that.
And are you aware of any literature or studies that look at the use of that discretion currently? Because I haven't seen much work done on that.
No, I know locally we've been fighting to get some data standards in terms of how we capture disaggregated race-based data. If we think about the entry points for data, it's typically with police or corrections. So I think we're missing an entire segment in terms of allowing people to self-identify at the courthouse, or having some accountability in terms of lawyers giving clients the opportunity to self-identify. But in terms of the use of police discretion for warnings or referrals to restorative justice, that I can't say that I've seen much research on it either.
And I guess my last question to you is somewhat similar to what I've just asked to the dispensary, and that is, do you think that Bill C-5 is a robust enough response to the existence of systemic racism in the justice system?
No, I think it's part of the answer. I think we need more upstream responses, but we certainly support this bill as part of the answer. This problem is so complex that we're not going to address it solely at the sentencing stage, but it doesn't mean that we're relieved of our obligations at the sentencing stage when people's liberty is at risk. So, in that sense, I support the bill. I do think there's a lot more work to do across the system. For example, I'd love to see a specific recognition of Black people in the criminal code in section 718(2)(e) as a type of response to further ingrain the fact that we're going to tackle overrepresentation in a really specific and targeted way, but this is a part of the answer.
Thank you very much.
Thank you, Mr. Garrison. Over to you, Mr. Morrison, for 5 minutes.
Thank you, Chair, and thank you to all the witnesses here today. Mr. Barn, Rick, I've got a couple of questions for you. And it's interesting that you are here talking about tobacco and illicit tobacco, and I'm sure a lot of people even in here thought, who cares? Like, how can that be a real problem? And it's interesting, a few years ago I worked on a file that had illegal tobacco, and I thought the same thing to myself in law enforcement. I thought, well, how can this be a real problem, until you get into the gangs and organized crime, and then you see where that whole event is going. And I'm sure a lot of people listening to this are probably having their eyes wide open as to what can happen with the illicit tobacco contraband. So maybe what I think would be interesting for me, and because you're a lot more recent than I am, is what do you see happening now that we know that it's just not tobacco, it's now getting into all sorts of illicit drugs, whether it's crystal meth or cocaine, it doesn't even matter. Just they're in major now organized crime, gang activity, shootings that we've seen everywhere. Of course, I get into the opioid crisis. I mean, that's a result of. But what have you seen in your experience that where this goes sideways, and what are the results, the victims, what's happening at the end of the day?
The contraband tobacco issue is, this sounds kind of strange, it's a unique issue, but it's not. So what I mean by that is it's the profitability for contraband tobacco for organized crime groups in Canada is absolutely significantly huge. And contraband tobacco is a Canadian problem. Most 90% of the contraband tobacco that we seize in our country is from, most cases, Ontario. So it's not something that's coming into our harbors and it's hidden and things of that nature. So the organized crime groups that are engaged are Canadian organized crime groups for the most part that are selling contraband tobacco in Canadian communities. This money that they make goes to fuel all kinds of crime that we're talking about here today. I understand these conversations so very well. I've lived these conversations for the last 20 years of my career. And, you know, I'm not here to comment from a policing perspective on these issues, but from a contraband tobacco issue, it's all intertwined now. I, for the last 10 years, do not recall a single person that we arrested or charged on contraband tobacco from at a significant level being engaged with any sort of a race-based group or from any sort of specific racial community. 90% of them were white organized crime figureheads. And that's who we're dealing with here. So I guess my message would be on the contraband tobacco issue, please don't just swipe it away with the rest of what C5 hopes to accomplish, for the record, which I'm not against. But this issue is unique from the perspective that organized crime is targeting contraband tobacco. They're pairing it with cocaine, fentanyl, all the issues that we're talking about today, and they're using it to make millions and millions and millions of dollars to serve them, use themselves.
Yeah, I wouldn't mind hearing a little bit about the policing side of it, but I mean, when you get, I mean, that's one of our major problems that we're trying to deal with is organized crime and gang activity, especially gun violence and how that can tear apart a community. It doesn't matter who's involved here, but it just, you know, you get shootings, young people, and it sounds as though if you give us some police experience.
Bells are going. Can I get unanimous consent if we go to 5:30 and then it has enough time to physically go to the? Nope, I see a no. So unfortunately, we will have to suspend here, and we don't have unanimous consent to go to 5:30. So I want to thank the panel. I want to thank all the witnesses for your important testimony today, and it's an important study. So we'll resume on Friday. Thank you.